In the rapidly evolving world of artificial intelligence, two names stand out above the rest: OpenAI and xAI. These organizations are not just companies, they are symbols of two competing visions for the future of technology and society. OpenAI, under the leadership of Sam Altman, has become synonymous with cutting-edge AI, thanks to innovations like ChatGPT and a high-profile partnership with Microsoft. Their approach is focused on developing powerful AI systems, but always with an emphasis on safety, ethical considerations, and responsible deployment. OpenAI's vision is to harness AI's potential while minimizing risks, working closely with industry leaders and policymakers. In contrast, xAI was founded by Elon Musk after his dramatic split from OpenAI. Musk's new venture is driven by a belief in radical openness and transparency. With its flagship product Grok, xAI aims to create AI that is less filtered and more accessible, reflecting Musk's conviction that fewer restrictions will lead to greater innovation and freedom of information. The rivalry between these two giants is both personal and ideological. It traces back to Musk's departure from OpenAI and his outspoken criticism of the company's transition to a for-profit model, which he argues betrays its original mission. This conflict has only intensified as both leaders publicly challenge each other's philosophies. What began as a series of public disagreements has now escalated into a full-blown legal battle, capturing headlines and sparking debates across the tech world. The outcome of this feud could have far-reaching consequences, influencing not just the companies involved, but the entire trajectory of artificial intelligence. OpenAI continues to champion safety, collaboration, and strong corporate partnerships, believing that careful stewardship is essential. Meanwhile, xAI advocates for open-source ideals and warns against the dangers of concentrated power in the hands of a few corporations, arguing that true progress comes from transparency and broad participation. The ongoing battle between Altman and Musk is about much more than business competition. It's a struggle over who will define the very soul and direction of artificial intelligence for generations to come. The stakes are enormous. Will the future of AI be shaped by a carefully curated, corporate-led evolution, or will it be driven by a chaotic, open revolution that empowers everyone? The answer could determine how AI impacts our lives, our work, and our world. At the heart of the xAI versus OpenAI dispute are trade secrets, confidential information that gives a company its edge. These are the hidden formulas, processes, or data that set one business apart from another, often representing years of innovation and investment. Trade secrets are not just technical blueprints. They can include business strategies, customer lists, or even unique workflows that are closely guarded from competitors. Trade secrets can be anything from algorithms to proprietary datasets, as long as they're valuable and kept secret. Unlike patents, trade secrets aren't registered. Their power is in their secrecy. Companies must take active steps to protect them, such as limiting access, encrypting files, and training employees on confidentiality. In AI, these secrets include model architectures, training data, and the specific weights that make models like GPT-4 unique. Companies fiercely protect these assets with NDAs and tight security. Even a small leak can give competitors a huge advantage, so organizations invest heavily in cybersecurity and legal safeguards. Losing a trade secret can cripple a business, letting rivals leapfrog years of research. In this lawsuit, xAI accuses OpenAI of misusing foundational knowledge developed when Musk was involved. The stakes are enormous, as the loss of such secrets can mean the difference between industry leadership and falling behind. The claim, OpenAI's latest models are built on secrets meant for the public good, not private profit. If proven, the consequences could be severe. Massive penalties or even halting OpenAI's use of its own technology. This could reshape the future of AI development and set new legal precedents for the industry. This is why the case is so high stakes for both sides. The outcome could influence how companies protect their innovations and how the world's most powerful AI tools are shared or kept secret in the years to come. In late 2025, xAI filed a dramatic lawsuit against OpenAI and Sam Altman, accusing them of trade secret theft. The suit claims OpenAI's upcoming GPT-5 is built on ideas and frameworks developed during Musk's tenure, secrets he says were meant for the public. xAI argues OpenAI's shift to a for-profit model, especially its Microsoft partnership, betrays its founding mission. The lawsuit seeks damages and an injunction to stop OpenAI from commercializing GPT-5. Musk's legal move is bold, framing the case as a moral crusade rather than just a business dispute. The suit paints Musk as a betrayed founder, Altman as the architect of a corporate takeover. This isn't just about money, it's a challenge to OpenAI's identity and the ownership of AI's foundational ideas. The tech world is watching to see how OpenAI will respond. xAI's lawsuit goes beyond code, arguing OpenAI broke a founding promise. Musk claims OpenAI was created as a non-profit to develop AGI for everyone, not for private gain. The suit alleges that early research and strategies developed under this mission are trade secrets, now misused for profit. xAI frames the company's mission and collaborative knowledge as assets that should remain open. By closing off this work and partnering with Microsoft, OpenAI is accused of a bait-and-switch. The legal question: can a company's founding mission and early-stage knowledge be considered a trade secret? Musk positions himself as the guardian of the original vision, seeking to hold OpenAI accountable. The court must now decide if a broken promise can be theft. In court, xAI's sweeping claims met a skeptical judge. The judge pressed xAI to specify what, exactly, OpenAI had stolen: code, data, or documents. xAI's answers were vague, focusing on ideas and mission rather than concrete evidence. The judge noted that abstract concepts and company missions aren't usually protected as trade secrets. Musk's departure years before GPT-4's development further weakened the case. The judge suggested the lawsuit seemed more like a public feud than a solid legal claim. Without clear evidence, xAI's case looked shaky. The message stories of betrayal aren't enough, proof is required. xAI faces a steep challenge, proving their claims with hard, irrefutable evidence in a world where secrets are rarely written down. In legal battles over intellectual property, the burden of proof is immense, and the stakes are high for both sides. Trade secret law demands specifics: what was stolen, how it was accessed, and exactly how it's being used today. Vague accusations or general similarities aren't enough. Courts want to see a clear, documented trail. xAI's argument that OpenAI stole its own mission is legally shaky. Ideas and broad visions aren't protected, only concrete, confidential information is. The law draws a sharp line between inspiration and theft, proving that early, open research is now a secret ingredient in GPT-5 is nearly impossible. Once information is public, it's no longer a secret, and the legal protection vanishes. The work done by OpenAI employees belongs to the company, not to a former co-founder. This is standard in tech, where intellectual property is tied to the organization, not the individual. AI evolves rapidly. What was cutting edge in 2018 is often obsolete today. The pace of innovation means yesterday's breakthroughs quickly become today's baseline. OpenAI can argue its current models are built on years of new research, not old secrets. Each generation of AI stands on the shoulders of countless incremental advances. For xAI, drawing a direct line from past ideas to present products is a legal long shot. The more time passes, the harder it is to prove a direct connection. The burden of proof is high, and so far, xAI's evidence is thin. Without a smoking gun, the case may struggle to gain traction in court. the case risks collapsing under its own weight, as the legal system demands clarity, not conjecture. And so far, xAI's claims remain difficult to substantiate. For OpenAI, the lawsuit is more distraction than existential threat. The judge's skepticism suggests the case may be dismissed, and OpenAI's legal team is well prepared. Still, litigation is costly and diverts attention from AI development. Musk's real weapon is public relations, casting OpenAI as a sellout to corporate interests. This narrative can erode trust, making it harder for OpenAI to attract talent and maintain its image. Even if the lawsuit fails, it forces OpenAI to defend its mission and reputation. The real risk is fueling broader criticism and regulatory scrutiny of powerful AI companies. OpenAI's technology and Microsoft partnership remain strong defenses, but the lawsuit keeps the company on the defensive, complicating its path forward. For Musk and xAI, the lawsuit is a high-risk, high-reward move. Winning in court is unlikely, and a loss could damage xAI's credibility, but the real goal may be marketing, positioning xAI as the open, ethical alternative to OpenAI. The lawsuit draws attention, appeals to open-source advocates, and distracts OpenAI. Legal discovery could force OpenAI to reveal internal details, even if no secrets are uncovered. Ultimately, xAI's future depends on its technology, not this lawsuit. If Grok and future models succeed, the lawsuit will be seen as clever strategy. If not, it will look like a desperate ploy. The market, not the court, will deliver the final verdict. The xAI versus OpenAI battle is more than a legal fight. It's an AI civil war. Musk's camp champions open source, arguing that democratizing AI is the safest path. OpenAI and others argue for caution, keeping powerful models under tight control to prevent misuse. This lawsuit brings the philosophical divide into the spotlight: openness versus safety, decentralization versus corporate stewardship. The debate: should AGI be open to all, or managed by a few trusted companies? Is OpenAI's partnership with Microsoft pragmatic or a betrayal? Is Musk's openness genuine or just a tactic? The outcome of the lawsuit matters less than the broader debate it sparks. The future of AI will be shaped by how we resolve these tensions, not just in courtrooms, but in public discourse. This is just the beginning of a much larger story that will define our era.